Good afternoon, ladies and gentlemen. The Subcommittee on Courts and Intellectual Property of the Internet will come to order without objection. The chair is authorized to declare recesses of the subcommittee at any time. We welcome all of our witnesses today. And I will give my opening statement at this point, as I think Mr. Conyers is en route, I'm told. Fair use was formally incorporated into our copyright law in 1976 and has been at the heart of a large number of copyright infringement disputes. Disputes over fair use range from cases that only pertain to individual uses of copyrighted works to cases involving high technology goods, which oftentimes can affect millions of consumers in congressional districts throughout the country. North Carolina, my state, is home to several large universities that rely upon copyright law to protect their research and innovation, and at the same time and through fair use to make other works available for libraries, scholarship, and other research. Fair use has an important role in our copyright system, and while it offers tremendous benefits, it has also raised some concerns, which is why today's hearing is so important. Rather than steal thunder from our talented panel of witnesses, I'm going to withhold my comments about the pros and cons of fair use until our expert witnesses have had an opportunity to lay out their arguments of what has worked well and what deserves additional scrutiny. As many of you know, the strength of fair use is that it's somewhat ambiguous, leaving the courts with the discretion to clarify what is and what is not fair use. This ambiguity is also, unfortunately, its greatest weakness, particularly in the digital era, because new technologies develop far faster than disputes are resolved in the courts. We have an important role, and many believe that we can do a better job providing the courts with guidance on what we intend and what we do not intend to be fair use, which could help resolve many disputes dealing with fair use. It is true that fair use can be very controversial, but I want to assure our witnesses and those in the audience today that all of the extra security you've seen today on the Capitol complex is due to the State of the Union address rather than the topic of this hearing. So we can all rest easy about that. So please feel free to speak candidly and help us understand how we can improve fair use and protect the rights of authors and creators. In closing, we welcome our eminently qualified panel of witnesses. Thank you for taking time from your busy schedules to join us today, and we look forward to hearing from you. I yield back my time and now recognize the distinguished gentleman from Michigan, the ranking member of the full committee, Mr. John Conyers.
Thank you, Chairman Coble. It's very kind of you to bring us all together again for this first hearing. Today's hearing provides an important opportunity to examine the scope of the fair use doctrine. As codified in Section 107 of the Copyright Law, fair use is an affirmative defense against infringement under certain criteria. As a starting point, I generally believe that fair use is working as intended. It provides a limited exception to the creator's property rights when certain public interests conflict with those rights. The current law attempts to strike a delicate balance between the public interest and a creator's ability to earn a living from his or her work. Creators should be able to tell new stories that contribute to public learning by using permitted copyrighted material as historical artifacts to depict real-world scenes and events. Historians, biographers, and filmmakers use these materials in their works to draw meaning and insights about historical events. The use of this copyrighted material is essential to discuss historic events, which is critical to news organizations and public broadcasters. Additionally, current law, while not perfect, provides reliable guidance to copyright holders. Although we must continue to monitor this area as digital technology continues to develop and change distribution of content, we must be vigilant in safeguarding the rights of creators. In particular, I want the witnesses today to address whether certain calls for expansion of fair use is due partly to the fact that specific statutory limitations have not kept pace with emerging technologies. And finally, content owners and user groups should continue to develop best practices to ensure that both of their interests are reflected. To be clear, I believe that the interest in maintaining the fair use's historic role as a flexible doctrine should continue to be applied in a broad range of contexts. We should also re-examine the application of quote-unquote transformative use standard. The transformative use standard has become all things to all people. Fair use impacts all types of industry, including filmmaking, poetry, photography, music, education, and journalism. We must continue to encourage these industries to develop best practices. I, too, look forward to hearing the witnesses discuss their opinions about the scope of fair use and what steps, if any, they believe we in Congress should take to make the law more effective and efficient. I thank you, Chairman.
I thank the gentleman from Michigan, Mr. Conyers, and the chair is now pleased to recognize the distinguished gentleman from Virginia, the chairman of the full Judiciary Committee, Mr. Goodlatte.
Thank you very much, Mr. Chairman. This afternoon, the subcommittee will hear about a crucial component of our nation's copyright law system, fair use. As a judicial doctrine, fair use has long been part of copyright infringement cases. As a statutory provision, however, fair use is a much more recent part of our nation's copyright law, codified in Section 107 only in 1976, with the exception of the last sentence of Section 107 that was added in 1992 to address fair use issues related to unpublished works. Section 107 has remained unchanged since 1976. Over the years, fair use has been widely recognized as providing flexibility in the copyright system, flexibility that has enabled commercial parity, and flexibility that has encouraged new business models in the tech sector. Fair use has been at the heart of several important Supreme Court cases, such as the Pretty Woman and Betamax cases. While there is no doubt that flexibility in the copyright system is beneficial, certainty with regard to our legal provisions is just as beneficial, both for copyright owners and copyright users. Not every dispute over what is and what is not fair use should require a judicial interpretation. So I'm interested in learning how the statutory provisions of Section 107 have succeeded since their initial codification in 1976. Are these provisions too specific or not specific enough? Are the current 4 factors the appropriate factors, and are they defined correctly? How should fair use interact with other provisions of copyright law? And probably the most important question, how does one define what is transformative? As several of our witnesses have noted in their written testimony, the test of what is transformative has been widely viewed by federal judges to be of primary importance. I look forward to learning more about this and other fair use issues this morning, and I thank the chairman and yield back.
I thank the chairman, and the statements of other members of the Judiciary Committee without objection will be made parts of the record. Ladies and gentlemen, there's a no taxpayer-funded prohibition for funding abortion. We on the floor later today. The Judiciary Committee has been given a time slot, and I think some of the members, John, may want to participate in that. So when that time slot arrives, we will stand in a brief recess, to accommodate those who want to go on the floor. So we'll try to keep this going as quickly as we can without keeping you all here until dark. We traditionally swear in our witnesses.
Mr. Chairman,
Yes, yes, sir.
Mr. Chairman, it is, I believe, the invariable custom of the House that a committee or subcommittee hearing does not occur while a committee bill is pending on the floor, and that means the entire committee bill, since I'm sure many members of the committee will want to be on the floor for debate on the abortion bill, a rather important bill, and should not be there, and would not want to be there only for a small segment of that debate. And I think that it is improper under the precedents of the House to have the subcommittee reconvene prior to or while H.R. 7 is still being debated on the floor.
Well, I say to my colleagues from New York, I don't set the schedule, the floor schedule, nor the subcommittee schedule for hearings. So hold me harmless for that.
Well, Mr. Chairman, I'm not seeking to place blame at all. I imagine that the intent was to have H.R. 7 started today, just do the rule and do the bill tomorrow, and have the ag bill, but the ag bill came up. But that is nonetheless where we stand now, and it is, I think, an imposition on the duties of the members of the subcommittee who have to participate in the debate on H.R. 7 to try to be in two places at once. And I think it wrong, and an adjustment ought to be made in the schedule of the subcommittee now, since we cannot control the schedule of the House.
Mr. Chairman.
Mr. Goodlatte.
Thank you, Mr. Chairman. Well, first of all, the committee ordinarily tries to avoid conflicting activities. We did not plan this hearing intending to have a conflict on the floor. We only learned of exact floor timing for H.R. 7 yesterday. Many of our witnesses have come from out of town. We need to make every effort to complete this important hearing. And this is a very important hearing, one of the most important hearings we'll hold on copyright law. And we have the State of the Union address coming up rapidly later on. So we have to take the time to get this done. We certainly should recess the subcommittee during the time that the Judiciary Committee will be managing the bill on the floor, but our committee rules state that the subcommittee should plan hearings with a view toward avoiding simultaneous scheduling of full committee and subcommittee meetings or hearings whenever possible. We scheduled this hearing. We were not aware of a potential conflict with floor activities. Nonetheless, the rule does not prevent us from moving forward today. And H.R. 7, the bill on the floor, while it's an important bill, and we have paid close attention to it in this committee, it's not primarily the jurisdiction of the Judiciary Committee. The subcommittee will, in my opinion, be best served by moving ahead expeditiously with our witnesses and our questioning of the witnesses, and then recessing at the time that our portion of the debate is in close proximity to beginning, allowing enough time for members to get over there for when it does begin. And I thank the chairman and yield back.
I thank the gentleman.
Mr. Chairman.
Gentleman from Michigan.
May I add to this discussion? First of all, I want to commend Jerry Nadler for initiating this discussion. I think that this conflict of an important bill coming out of Judiciary being on the floor and we being overlapped with important hearings and distinguished witnesses at the same time, that this should serve as an example for all of us, that this should not happen again under any circumstances for the remainder of the 113th Congress.
Well, I thank the gentleman. Having said all that, I think we need to move along because we have out-of-state witnesses here. As I say, I don't want to keep you all here until the last dog is hanged tonight. So we traditionally swear in our witnesses. If you all would please stand and raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record reveal that all responded in the affirmative. And now I'm pleased to recognize our witnesses. Our first witness today is Mr. Peter Jaszi, Professor of Law at American University, Washington College of Law, and Faculty Director of the Glushko-Samuelson Intellectual Property Clinic. Professor Jaszi teaches domestic and international copyright law as well as law and literature. Professor Jaszi received both his JD and AB degrees from Harvard University. Our second witness is Ms. Jude Besek. Correct pronunciation, Ms. Besek?
Besek.
Lecturer in law at Columbia School of Law and Executive Director of the Kernochan Center for Law, Media, and the Arts. In her position, she oversees studies on national and international intellectual property issues. Professor Besek received her JD from New York University and her BA from Yale University. Ms. Novik, our third witness, is author and co-founder of the organization of Transformative Works. Ms. Novik is best known for her fantasy and alternative history series of novels. She received her master's in computer science from Columbia University and BS in English literature from Brown University. Our fourth witness, Mr. David Lowery, is singer and songwriter and lecturer at the Terry College of Business at the University of Georgia. As a guitarist, vocalist, and songwriter, Mr. Lowery founded the alternative rock band Camper Van Beethoven and co-founded the rock band Cracker. He received his BA in mathematics from the University of California, Santa Cruz. Our final witness is Mr. Kurt Wimmer, General Counsel for the Newspaper Association of America, a nonprofit organization representing publishers of more than 2,000 newspapers in the United States and Canada. Mr. Wimmer received his law degree and master's degree from Syracuse University and his bachelor from Missouri School of Journalism. We welcome you all, and in view of the time restraints, we would appreciate your confining your statements, if you can, in on or about 5 minutes. There's a panel on the table that will reflect green, amber, and red. When the red light appears, the ice upon which you are skating will become thinner and thinner. You won't be keel hauled, but we will ask you to. We try to comply with the 5-minute rule as well. So we will start, Professor, with you. You'll be our first witness.
Thank you, Mr. Chairman, and thanks to the members of the committee for this invitation. The Fair Use Doctrine helps guarantee the continued international primacy of the United States as a site of innovation. After a rocky start, the courts now are doing an excellent job of implementing the legislative direction contained in Section 107, which itself restated more than a century of case law. Fair use doesn't need reform, but it could use legislative support. For example, Congress could exempt non-commercial creators of derivative works from potentially onerous statutory damages, which today chill the exercise of fair use. Congress could further enable fair use by amending Section 301, which deals with federal preemption of state law, to bar some or all contractual waivers of the fair use right. In my written testimony, I tried to describe the current unified field theory of fair use that informs decisions from every part and at every level of the federal court system today. As already noted, that unified field theory is keyed to the notion that uses that advance transformative ends, those that repurpose and add value to copyrighted material they employ, deserve special consideration. Yesterday, a Second Circuit Court of Appeals panel provided an illustration. The Bloomberg Professional Service had posted the recording of a conference call between executives of the Swatch Group and hundreds of registered financial advisors on its site, and Swatch had complained. In finding fair use, the court noted that in the context of news reporting and analogous activities, the need to convey information to the public accurately may in some instance make it desirable and consonant with copyright law for a defendant to faithfully reproduce an original work. In such cases, the court continued, courts find transformation by emphasizing the altered purpose or context. The court also made it clear that Bloomberg's use of the entire recording was reasonable in light of its purpose of disseminating important financial information to American investors and analysts. The point, again, and I want to stress this, was that Bloomberg was serving the collective public interest in access to information without working great harm to any competing private interest. It's not surprising to see fair use at work in the journalism sector, given that the Supreme Court has stressed the intimate connection between the fair use doctrine and the First Amendment. More broadly, however, we've seen over the past 20 years how the fair use doctrine is experienced as an important positive right by readers and publishers, movie producers and remix artists, tech incumbents and startups, teachers, developers of educational materials, artists, scholars, librarians, providers of disability services, filmmakers, and other contributors to the kind of progress that our IP laws serve. Of course, not every person in every sector likes every fair use decision, but we've all benefited collectively from this general pro-innovation trend in our copyright law. The pattern of decisions of which this Bloomberg case is the most recent example articulate no a priori limits on the range of situations to which the doctrine is potentially applicable. They don't limit it to situations involving the creation of new copyrightable works or anything of the kind. And given the ultimate goal of copyright, which isn't to favor any particular form of expression over others, but to promote the production and dissemination of useful knowledge, there's no apparent practical, non-ideological reason why such limitations would be desirable. At the very least, those who would now seek to rein in the future development of the fair use doctrine have a heavy burden of persuasion to demonstrate why doing so would be in the public interest. We value fair use for its flexibility and dynamism, which allow courts to adapt the doctrine to new social, economic, and especially technological circumstances. This isn't to denigrate the value of static specific exceptions in copyright law, like sections 108 for libraries or 110 for education or 121 for the print disabled. Where these apply, they're valuable, highly valuable to particular groups of users because they provide high levels of certainty. They are, in effect, safe harbors, even though never comprehensive and often not up to date. As Congress and the courts have recognized repeatedly, these provisions do not supplant fair use. Rather, they are supplemented by it. As Mr. Coble noted, one common critique of fair use is that its commendable flexibility gives rise to unacceptable levels of uncertainty. In fact, however, recent scholarship tends to show that fair use jurisprudence is both patterned and predictable. Lawyers and their clients actually have relatively little real difficulty forecasting likely fair use outcomes in areas where there are direct or even analogous precedents. Also contributing something to the predictability of fair use is the work of professional organizations that are developing fair use best practices, documents to guide their constituents in exercising their fair use rights responsibly and constructively, a tendency to which Mr. Conyers referred earlier. Finally, though, the greatest credit for the healthy state of fair use law belongs to users, large and small, who invest time and thought in making sound fair use decisions, thus helping to assure the condition of cultural flourishing, which is the constitutional objective of copyright in the United States. I should add then that we at American University have been very pleased and proud to be involved to some extent in the work of developing fair use best practices and have over the last decade been able to collaborate with a wide range of different professional organizations, beginning with documentary filmmakers, moving over the decade through a number of different areas of practice to the present day when we are working with the College Art Association on developing a comprehensive code of best practices for
Professor, your time has
visual
expired.
arts.
Your time has expired. I failed to tell you folks, when the illuminated red goes to illuminated amber, that is your 4-minute warning. But Professor Besek.
Thank you, Mr. Chairman and members of the committee, for giving me the opportunity to be here today. In early 2008, Columbia Law School sponsored a day-long symposium titled Fair Use, Incredibly Shrinking or Extraordinarily Expanding. What was apparent 6 years ago is even more obvious now. Fair use is extraordinarily expanding. Until recently, the courts held that generally it's not a fair use if you copy an entire work. From the point where copying an entire work generally defeats fair use, now copying the full contents of millions of works can qualify as fair use. So why might this expansion spark concern? Fair use is an essential part of U.S. copyright law, but it isn't meant to be a carte blanche to make unlimited use of others' works, even for a socially beneficial cause. The rights of creators and the interests of users have to be balanced. How did the law move so far so quickly? Well, the principal reason for this expansion has been the increasing significance of transformative use in evaluating fair use. This happened since the Supreme Court's decision in Campbell against Acuff Rose. You may know that opinion. It had to do with a parody of, by Two Live Crew of the song Pretty Woman. Now, the Sixth Circuit had said Two Live Crew did not make a fair use. It had relied on an earlier case which said that commercial use is presumptively unfair. The Sixth Circuit resolved factors 1 and 4, which are often considered to be the most important, on the basis of this commercial use. Its decision wasn't atypical. A lot of courts had been doing that, depending on the commercial use and making commercial use virtually dispositive of fair use. In reversing, the Supreme Court said commercial uses can be fair. That's one aspect of factor 1, but another important one is transformative use. And that's using a work in a way that adds something new, altering the other work with new expression, meaning, or message. Like Campbell itself, earlier fair use cases involved productive uses, and they were premised on use of the work itself. For example, to annotate, to analyze, to create a parody. But post-Campbell cases began to interpret transformative in two significantly expansive ways. First, to encompass not only changes to the substance of a work, but also changes to how the work is used. They referred to this repurposing as functional transformation. But the second aspect, and more concerning, is that courts began to apply the transformative and functional transformation labels not only to new works that incorporate unaltered copies of earlier works, but also to new uses that exploit the prior work without creating a new work. So transformative has been uprooted from its original context of new works to become applied to a much broader context of new purposes, enabling new business models rather than new works of authorship. One troubling consequence is that if a court finds that defendants' use of an author's work is transformative because it reaches new markets or a new audience, that finding can usurp the author's derivative work rights, particularly with respect to potential markets for the work. Because once a court has found that a transformative purpose exists with respect to a new use, it tends increasingly to find that the new use exploits a transformative market that doesn't compete with the author's markets. Basically, authors' rights can hinge on a race to the market for new and sometimes unanticipated uses. Now, over the years, fair use case law has sometimes strayed too far in one direction or the other. I mentioned earlier that courts had been using commercial use as dispositive of factors 1 and 4 because of the Sony thing about the statement in Sony that commercial use is presumptively unfair. And in Campbell, the court stepped in to try to restore that balance. But now the pendulum has swung the other way. A finding that a use is transformative tends to sweep everything before it, reducing the statutory multi-factor assessment to a single inquiry. It's important that the fair use pendulum once again be moved back toward the center. Despite the concerns I just voiced, fair use remains a rule whose application is best made by judges, as the Congress recognized when it first put fair use into the statute back in the 1976 Act. But as we've seen, the pendulum can swing in both directions. There are times when legislative intervention may be appropriate when that application proves too rigid or too expansive. I think the current judicial expansion of fair use may reflect concern to preserve the benefits of mass digitization, notwithstanding the tension between mass digitizing and the Copyright Act itself. I think without altering the text of Section 107, Congress might separately address the problems of mass digitization, which I think is skewing the law. If Congress turned its attention to those issues, it might relieve the pressure that risks turning the fair use doctrine into a free pass for new business models and restore fair use to its most appropriate role of fostering new authorship. Thank you.
Thank you, Ms. Besek. Ms. Novik.
I'd like to thank the House Judiciary Committee for inviting me to testify about fair use and its role in promoting creativity. I'm not a lawyer, but as one of the creators and artists whose work is deeply affected by copyright law, I hope to explain how vital fair use is to preserving our freedom and enabling us to create new and more innovative work. Today, I am the published author of 10 novels, including the New York Times bestselling Temeraire series, which has been optioned for the movies by Peter Jackson, the director of The Lord of the Rings. I've worked on professional computer games and graphic novels, and on both commercial and open source software. And I would have done none of these things if I hadn't started by writing fan fiction. I found the online remix community in 1994 when I was still in college. For the next decade, before I wrote one word of my first novel, I wrote fan fiction, built online computer games, wrote open source archiving software, and created remix videos. I met hundreds of other artists creating their own work and found an enthusiastic audience who gave feedback and advice and help. We weren't trying to make money off our work. We were gathering around a campfire. We were singing, telling stories with our friends. The campfire was just a bigger campfire thanks to the internet. And instead of telling new stories about Robin Hood, we told new stories about Captain Picard, because that's who we saw on our television every week. Fair use gave us the right to do that. And I'm not a lawyer, but I can tell you that for all of us, what we were doing felt absolutely fair. We watched Star Trek every week religiously. We bought the T-shirts and the videotapes and the spin-off books, and when the DVDs came out, we bought those too. Of course, we were going to have our own new ideas about the characters, about the universe, about what might happen. That's what we do. We're imaginative creatures. And of course, we wanted to share our ideas with each other. I learned to explore ideas in the remix community and to see where they led me. And eventually, they led me to my own characters and my own universe. And now other artists, other remix artists, are writing fan fiction for Temeraire. And they make fan art, and sometimes they even send me a stuffed Temeraire to give to my 3-year-old daughter. And I hope that one day, one of the fans writing Temeraire fan fiction will go on to write their own bestseller or make their own movie or game, perhaps with an idea sparked by something that I wrote. We all build on the work and ideas of people who came before us. In fact, that's the only way to innovate. There isn't a hard line between remix work and work that stands on its own. Original work is at the end of a natural spectrum of transformation, and fair use protects the spectrum. It creates a space where artists can play with ideas and develop our skills, share our work within a community, and learn by doing. Licensing is just not a realistic alternative. On the purely practical level, the vast majority of remix artists doing non-commercial work simply don't have any of the resources to get a license. Not money, not time, not access. I wrote my first fan fiction story as a sophomore in college, taking 5 courses, working a part-time job, doing page layout for the Campus Weekly, and occasionally calling my parents. If I'd had to pay someone and go through a complicated licensing process to get to the point of writing that story, I would never have done it, and I might never have written my own novels in the end. Imagine if kids who watched The Lone Ranger and ran outside to make up a new adventure in the backyard had to get a license before doing that. And today, the internet is increasingly becoming our shared backyard. And speaking also as a copyright holder, licensing is not a practical option for most of us on the other side of the problem as well. Most artists are not large media conglomerates with substantial legal departments. I am delighted for other artists to make fair use of my work, but I don't want the difficulty and the expense and the legal risk of having to give a license to every kid who might want to write a story where they become the captain of a dragon in the Temeraire universe. More importantly, licensing still doesn't work even if the practical considerations are removed, because licensing invariably stifles transformative work. I know authors who've written licensed tie-in novels, and they always face a long list of requirements, and at the end of the book, they have to bring everything back to the beginning. The point of licensing by the copyright holder is almost always to avoid transformation, because by definition, transformative work is one that doesn't match up to the copyright holder's vision. I see I'm running out of time, so I'm going to skip a little bit ahead and ask Congress to make it easier for developing artists like the one that I once was, who are often at a significant disadvantage currently, to exercise their fair use rights. Most remix artists, especially ones just starting out, don't so much as know a lawyer. They don't have the resources to defend themselves against even the most frivolous lawsuit or an automated takedown. Congress could give tremendous support to the incubator of remix art by making it less frightening to take the chance of creating. Artists creating transformative work should not be asked to pay more in damages than they have earned from their work, so long as they acted in good faith. Congress could also require platforms that create automated screening tools for copyrighted work to provide a straightforward way for artists to identify their work as transformative and make a claim of fair use. And Congress could add a specific exemption for non-commercial transformative work that would supplement fair use, the same way that libraries and teachers have specific exemptions that provide a clear safe harbor. In general, I strongly urge Congress to resist any suggestion of narrowing fair use, including by trying to replace it with licensing. Innovation starts with asking, what if? What if we could build a machine that could fly? What if you crossed a cell phone and a music player? Our country is the world leader in innovation precisely because here we ask those what-if questions. Thank you very much.
Thank you, Ms. Novik. Ms. Besek, you're the only witness so far to beat the red light. Now I'm imposing pressure upon Mr. Lowery. Mr. Lowery, you're recognized for 5 minutes.
I may have a distinct advantage, Mr. Chairman, since I'm used to expressing myself in less than 5 minutes.
As I said, we won't penalize you if you fail in that effort.
Okay. Chairman Goodlatte, Chairman Coble, Ranking Member, and members of the subcommittee. My name is David Lowery, and I am a mathematician, writer, musician, producer, and entrepreneur based in Richmond, Virginia, and Athens, Georgia. I also teach music business finance at the University of Georgia. Thank you for this opportunity to speak with you today about the scope of fair use. The rise of the Internet corresponds with recent attention devoted to fair use as an excuse for trumping the rights of authors established both in the U.S. and other countries. This attention comes from technology companies, commentators, lobbyists, and some parts of the academy. I am not concerned with parody, commentary, criticism, documentary filmmakers, or research. These are legitimate fair use categories. I am concerned with the illegal copy that masquerades as fair use, but is really just a copy. This masquerade trivializes legitimate fair use categories and creates conflict where there need be none. These interpretations of fair use have become important to my daily life as a singer-songwriter. There are attempts by certain websites and commercial services to pass off as fair use versions of my work that are indistinguishable from my work. As I will demonstrate, these works compete directly with licensed instances of my work. As a professional singer-songwriter, I believe that fair use doctrine, as intended by Congress, is working in the music business and music industry and should not be expanded. Sampling and remixing is one arena where there has been a push for expanded fair use. This defies logic, as there is no emergency. Hip-hop relies on samples of other artists' work. There exist robust market-based mechanisms for licensing these samples, and hip-hop has gone on to become the most popular form of music on the planet without expanded fair use. Don't fix it if it ain't broke. I go into great detail in my written testimony. Another arena is song lyrics. Some commentators have suggested that sites that reprint song lyrics with annotations or meanings may be covered by fair use. I have personally experienced the unauthorized use of my lyrics on one of the most famous lyric annotation sites called Rap Genius. Exhibit 1 shows an example from this lyric annotation site. I research lyric sites as part of my academic work at the University of Georgia and produced the UGA Top 50 Undesirable Lyric website list. After I published my most recent update to the list, which placed Rap Genius at number 1, their editor-in-chief of Rap Genius transcribed the lyrics of my song Low and began annotation of my lyrics. These annotations are invisible in the exhibit. They appear only as hyperlinks to pop-up windows. Now, note these links could refer to anything. How is this use any different from the use of my lyrics on the non-annotated and licensed site? These are virtually identical. The Rap Genius instance of my lyrics is nearly identical to this one. How is it fair use? It competes directly with the revenue I receive from this licensed site. Following this logic, I could reprint an entire book and occasionally provide a hyperlink to the definition of a word. Indeed, the owners of Rap Genius seem to agree that their use is not fair use, as evidenced by their recently completed licensing deals with Sony ATV Music and Universal. My final point before thanking the subcommittee for this opportunity to speak today is what's so hard about asking permission. As an artist, I only expect to be treated as I would treat other artists. I believe that permission, or the legitimacy of consent and doing unto others, are the very foundations of civilizations. The rights holders have never been easier to look up. Millions of recordings can be identified with an iPhone application or looked up in a public database at no charge. It takes little effort. In conclusion, I respectfully request that the members of the subcommittee review the practical history of the application of fair use defense to see that it is working as intended. I hope you will agree with me that no legislative expansion or governmental intervention is needed at this time. Thank you very much.
Thank you, Mr. Lowery, and you prevailed over the red light.
Barely.
Mr. Wimmer.
Chairman Coble, members of the subcommittee, thank you for having me here today. The professional reporting that newspapers publish starts important conversations in the communities that we serve. We recognize that this conversation often continues online, both on platforms that our industry owns and on those owned by others. Because our content is a central part of these conversations, the scope of fair use is an important issue for the news industry. The newspaper industry spends about $5 billion a year gathering and producing news and information. We're also investing heavily in new online and mobile platforms to deliver content to readers. As a result of these efforts, newspapers have a larger audience than ever before. Newspaper circulation revenue grew 5% in 2012, and digital-only circulation revenue grew by 275%. Nearly 65% of all U.S. adults read newspaper content in a typical week or access newspaper content on a mobile device in a typical month. The digital future, then, is bright, but there is much ground to make up because of the unprecedented disruption caused by the digital transition. For every $15 in print advertising revenue lost, newspapers have gained only $1 in digital advertising revenue. Competition for viewers in the digital world is fierce, and our publishers increasingly find themselves competing not only against companies that create original content, but also with companies that build businesses on the backs of the very news content that our members produce. Newspaper content makes up 66% of the content on news aggregation platforms such as Google News. Newspaper content also makes up more than half of the content on many popular digital platforms. These uses can result in some limited traffic to newspaper sites, but most don't result in meaningful revenue. The platforms using our content, however, certainly benefit by using news content to build and monetize readership on their sites without paying a dime for the use of that content. Some of the uses of newspaper content certainly qualify as fair use, while others clearly do not. But this is an issue that we think can be remedied by the courts rather than Congress. We believe the current state of the Copyright Act, including the formulation of fair use, strikes the right balance and should not be changed. The fair use doctrine has been developed over decades as a common law concept, allowing courts to respond to changes in technology. This case-by-case analysis allows courts to balance the competing individual interests at hand and to capture both those needs and the welfare of society as a whole. A recent example of a court deftly applying this fair use doctrine is the Southern District of New York's decision in Associated Press versus Meltwater. Meltwater is a for-profit reporting service that scraped AP articles and delivered verbatim excerpts of them to its paying subscribers. The court properly found that Meltwater's customers viewed the service as a substitute for reading the original articles, judging by the minuscule click-through rates. The court held that Meltwater's republication of segments of news articles without additional commentary or insight was not transformative and not a fair use. Targeted enforcement actions focusing on commercial ventures that simply take and resell our content may continue to be necessary. Of course, not all fair use decisions are decided correctly. In particular, some courts' recent willingness to give undue weight to the concept of transformative use is troubling. This undue weight and the surprising types of rather pedestrian uses that have been found to be transformative risks allowing that element to subsume the other equally important factors. We hope and expect that this imbalance in applying the fair use factors will be corrected over time. Another reason that the Copyright Act need not be changed is because licensing arrangements are becoming more realistic in many industries, including ours. We believe that many participants in our ecosystem, particularly innovative startup ventures and social media platforms, would really prefer to deploy solutions that rely on licensed content rather than to rely on questionable business models such as scraping in violation of copyright and terms of use. Licensing news content allows that content to be distributed on new platforms, but helps to support the cost of high-quality original journalism. In all, our goal in the digital world remains consistent with our longstanding mission. We seek to inform audiences as broadly as possible about the communities in which they live. In the digital environment, we will seek the appropriate balance of enforcement, licensing, cross-industry partnerships, and deploying our own new platforms to achieve this goal. And continued reliance on steadfast areas of law, such as fair use, will be essential as we continue to move forward. Thank you for the opportunity to testify, and I look forward to your questions.
And you also prevailed, Mr. Wimmer. Thank you.
Well, Mr. Lowery raised the bar.
And I'm not penalizing you, Mr. Jaszi, by association. Folks, we try to comply with the 5-minute rule ourselves, so if you could be terse in your response, we would be appreciative. I'll start. Let me start with you, Mr. Wimmer and Mr. Lowery. What, with the focus of transformative uses, what in your minds are transformative works for the purpose of fair use, and what is not?
Well, it's a good question, and it's one that is very fact-based. You know, the transformative works that I have not been that I really haven't been pleased with are the ones that have sort of allowed secondary uses to simply take copyright owners' work, use it in a very straightforward manner, and claim it's transformative. The case that really does stick in my craw is the Grateful Dead case, in which a publisher was making a coffee table book about the Grateful Dead, which seems to be sort of a contradiction in terms, and took Grateful Dead posters over the years and put them in chronological order. The court then found that simply putting those posters in chronological order transformed them into something else, which I really do not agree with. The Bloomberg case, however, I think is an interesting, which the professor talked about, I think is an interesting transformative use case that I do think makes a lot of sense for the reasons that the court announced just yesterday.
Mr. Lowery, you want to add to that?
Well, yes. I mean, my example that I showed before is an example which is some commentators argue is a transformative case. As you can see, the reprinting of my lyrics on a site which has yet to license these lyrics. And this site, which I'm sorry about the lady on there, but every ad I hit had something like this. I don't know if it's because I was at the airport or what.
No apology necessary.
Yeah. But this is the same instance of my lyrics here, but some commentators have claimed that this is transformative because you can click on these hyperlinks and they might go to another window or a pop-up or something like that that has maybe an explanation of a word, or says, oh, he's referencing Baudelaire right here, which, by the way, is a perfect example of fair use. I subtly reference Baudelaire here. Well, actually, I mean, that doesn't even involve fair use because I believe that is in the public domain. So this, to me, is a case of something that is not transformative that people argue is transformative. And so it competes directly with this, for which I make, well, micro pennies for each page view, but it is a market. It has been established. There's market-based mechanisms. There's, agencies that license these. There's a free market in the reprinting of song lyrics.
Thank you, Mr. Lowery.
Thank you.
Professor Jaszi, should a definition of transformative be codified?
I think that
Mike, please.
It would be a great mistake at this time to attempt to arrest this judicial development or this process of judicial development that is well underway. We have resisted over time codifying in detail other aspects of the fair use doctrine, the results have been enormously productive in terms of social, cultural, and technological innovation. For the same reason, I think the reduction to a narrow description of transformativeness would be a great error at this time.
Thank you, sir. Professor Besek and Ms. Novik, are there recent fair use decisions with which you disagree, and why?
Well, there are a number of recent decisions which I disagree with, but one comes to mind immediately. It was a case that dealt with whether use within a law firm of certain scientific articles was fair use or not. The argument for functional transformation was that the law firm was trying to decide if it needed to submit the articles to the PTO as evidence of prior art. But the argument was that, well, these articles are published so that people can understand new scientific developments. And the law firm is only using them to see if they're prior art, but they're both reading them. They're both reading them to see what substance is contained in the article and what it says about scientific development. So I don't think that that is a transformative use. It may be excused on other grounds, but it's not transformative.
You want to add to that, Ms. Novik?
I am not a lawyer, so of course I'm not as familiar with various cases that are coming out. But I will say that I think transformative is one of those things where you kind of know it when you see it. And to actually speak to the case that Mr. Wimmer mentioned of the Grateful Dead posters, I actually happened to see an example of this. The coffee table book presented the posters in thumbnail form and in chronological order in a way that, at least for me as a simple reader, I actually found did add information and did not replace the original. You know, if you want a big poster of the Grateful Dead on the wall, it's not the same thing as looking at a page in a coffee table book that has 7 or 8 posters showing you the evolution of the style of the Grateful Dead. So I actually felt that that was a reasonable judgment. And so far, at least, I feel that the courts have generally been making interpretations of transformative that, at least for myself as a creator, have made certain sense.
Thank you for that. And I plead guilty. I failed to prevail with the red light. Ms. Chu is recognized for 5 minutes.
Thank you, Mr. Chair. As co-chair of the Creative Rights Caucus, I'm so glad to see that we have individual creators here on today's hearing. And in particular, I want to welcome back David Lowery to Capitol Hill. He is an outspoken singer-songwriter who's not afraid to speak his mind on key copyright issues for the purpose of advocating for creative rights. So thank you, Mr. Lowery, for speaking out for individual creators who simply want to preserve their right to make a living from their works, but often face many unique challenges. And in fact, let me start with a question for you, which is on remixes and illegal lyric websites. In your testimony, you seem to indicate there's a right way to sample music, and that a permission-based solution is possible. You offer hip-hop and electronic dance as examples of music that rely on sampling and remixing. So why is it that some choose not to do it the right way when our current copyright system has allowed, as you say, market-based mechanisms and conventions to evolve and facilitate the licensing of sample and remixes? And then let me also ask about lyric websites as a lesser-known kind of copyright infringement. You conducted a study to figure out how rampant this type of online infringement is and have even experienced that with your own lyrics. Can you tell us how serious and prevalent of a problem illegal lyric websites are?
Well, I'll start with your second question. The lyrics were they're an interesting case for the digital age because really a lot of artists, there was no market for their lyrics because the fixed cost to print a book was too high. So this is actually a success story for the internet and music. One of the few ones is that there actually is a market for relatively obscure artists to market their, essentially get some small amount of revenue from their lyrics. So, And generally, the lyric websites have generally been licensed. Not all of them, but it's looking at the traffic, about half of them or a slight majority of the traffic to these websites has been licensed. But what started to pique my interest is that there seemed to be backsliding and a push for fair use based around sort of annotations or meanings of the songs. And these are directly competitive with like I said, directly competitive with the market that already exists, which has sort of established a market price, has established uses, and all of that. Speaking to EDM and hip-hop, I often hear that there's been some sort of, sort of that hip-hop is not as innovative as it once was because of various rulings and stuff like that. People don't sample quite as much as they did before and stuff like that. All I can say is I'd just like to point out that the market basically disagrees with that because hip-hop is now more popular than it ever was. So those rulings that may have sort of restricted some uses actually didn't affect the popularity of hip-hop. And finally, generally, having owned a studio for 20 years, I see that people tend to do what copyright intended when they are not able to obtain a license for a song that they sample. They tend to do what was intended in copyright. They create a new loop, we call them loops, to take the place of the sample. That is, they create a new work, which is something that I believe the Founding Fathers intended in the copyright clause.
Okay. Thank you for that. Professor Besek, you expressed concerns with how there is the use of fair use in trade promotion authority. And I understand that the courts don't always get it right, especially as digital technology continues to facilitate the reproduction and distribution of content in ways not contemplated by Congress. But some people are pushing for required exporting of our common law of fair use. What are the potential consequences of this if to the U.S. standards of fair use?
I think the idea of exporting fair use is a really interesting one, although I don't think this is the time to do it, and that's because I think we have enough uncertainty here in our fair use doctrine that we should not be sending it to other countries. But the part that I think is especially interesting is I think some people are assuming that fair use, when exported, would be the same. But we've had so many different cases in the United States where fair use has switched from the district court to the appellate court to the Supreme Court. And in another country, it could have gone the other way. So I don't think we can assume that fair use applied in another country would look like it does here. And the other point is that other countries have very different copyright laws in the sense that they don't have a blanket exception. They have very specific exceptions. And for us to be imposing our fair use exception on them wouldn't sit very well when they, in fact, cover a lot of the same uses that we do, but just in a different way.
Thank you. I yield back.
Gentlelady's time has expired. We have time for one more round of questions before we go vote. The gentleman from Pennsylvania is recognized for 5 minutes.
Thank you, Chairman. Professor Jaszi, I'd like to begin with you, sir. Where do you draw the line on the fair use? Where do you draw the line on copyright using particularly lyrics from music or poetry?
I think that the line is properly drawn, although it is not easily drawn, between those uses which are genuine value-added uses, which do infuse commentary, critique, and other added value into the material used.
So you don't support the fair use, then you just think that everything is game? It can be used by anyone out there?
I don't think that was my answer.
Okay.
I was about to say that by contrast, there may be situations, and perhaps some of the sites to which Mr. Lowery refers are such situations, in which the the added value or repurposing is pretextual rather than real.
Okay, now I'm limited time here, sir, so I would love to discuss this all day long with you because you seem you're certainly aware of it, but I have to move on with my line of questioning. I hear constantly from musicians, artists, individuals who supply the lyrics, supply the music, who are waiting on tables in restaurants, and they see their music, their lyrics on the internet. They receive nothing for that. Do you have any problem with that whatsoever?
I don't believe that the kinds of complaints about the use of music in public places, for example, to which you refer, are even arguably covered by fair use. They are maybe enforcement issues concerning how well the music industry does, in fact, impose on restaurants which are subject to...
No, you misinterpreted. I'm sorry, maybe I wasn't clear enough. I don't mean using the material, playing it. I mean that these artists, these writers who write the lyrics, then this music goes, makes a lot of money, and then pirates on the line on the internet are using this music and selling it.
I don't believe that anyone, certainly not myself, would defend internet piracy as a form of fair use. It lacks all of the characteristics of transformative use, repurposing, and addition of value, which the courts have identified over the last 20 years as the earmarks of fair use.
Okay, so you don't have a problem with the courts then interpreting, as was Attorney Wimmer stated, I'm very sorry, that let's let the courts, it's common law, let's let them make that determination?
I'm sorry.
Do you have any problem with the courts then making that determination on the 4 points that they usually use to determine whether there is transformation or not?
Oh, I think that's exactly the way we should proceed.
Okay. Let me pose this scenario, and please don't take it personally. You're a lecturer, and what would your position be that concerning wherever you lecture, your employer pays you for that lecturing, so they video your lectures, and then next year they say we don't need you anymore, we're just going to run your videos and not pay you for them. What is your position on that?
Well, they do that already, and so far I have survived. It's essentially a contractual.
But sir, there's the key. Therein lies the phrase. You have survived. Many of the people in the entertainment industry and writers, they are not surviving. Fortunately for you, like myself, we have an income that we can live on. But individuals with the talents that I don't have are out there writing books and beautiful music, but yet are getting maybe a few cents, if at all. So I would have to think that based on what you said, you agree with me that they must be compensated.
Oh, I absolutely agree, but the problem here is not a problem with copyright. Just as I am defended in my workplace by my contract, so the essential problem relating to the return from the market to creative people is a problem of contract rather than
So why limit it then with your position? Why limit it to copyright? Why not trademark? Why not patents?
Well, we do have a very vital doctrine of fair use in trademark law, and the patent law, although it is different in its nature, far shorter in duration, is also subject to a number of public interest exceptions. So
but it's far more, they're far more stringent than we are in the copyright areas.
Well, again, I would make a distinction. I think I would probably differ slightly with respect to trademark. I think trademark law actually is as porous or more porous than copyright law. But as to patent, there is a significant...
I see my time has elapsed and we have to go vote, but thank you so much. I appreciate the exchange.
I thank the gentleman. The gentlelady from California asked to be recognized.
Thank you, Mr. Chairman. I would like to ask unanimous consent to put into the record some fair use principles for user-generated video content submitted by a variety of advocacy groups.
Without objection. Ladies and gentlemen, the committee will stand in recess for this series of votes, but members should be advised that we will resume the hearing immediately after the votes. We will continue until it's time for Judiciary to manage its portion of H.R. 7 on the House floor. So we'll stand in recess until we come back. We'll continue to hear from the gentleman from Pennsylvania until we wait for the others to show up. The gentleman from Pennsylvania.
Innocuous question for the lawyers, and we can start with Mr. Wimmer. If you have followed the cases that have come down through the federal courts, following the law, the common law that has been established, and I'm going to ask the others to respond to it too, were you able to see that there was a relative consistency in the court's opinions?
It's an interesting question. I think there was a substantial amount of consistency until about the late 90s, when the transformative use concept really started to ascend. And now, when you look at cases like the Kelly versus Aribasoff case and Perfect 10, and even through Google Books, it almost seems as if the transformative use piece has really unsettled the marketplace. But in terms of the rest of the factors, it's been pretty consistent, I think.
Professor Besek, and then Professor Jaszi.
I think that where you start finding inconsistencies is when there is a genuinely new use. So, for example, you see courts really split on issues, and it's hard to predict whether a new use will be fair or not. I mentioned earlier that in some of these cases, like Sony, you have, the district court goes one way, the appellate court goes another way, the Supreme Court goes another way, and then sometimes a decision is originally written by what turns out to be the dissent. So that's where I think the principal areas of difference between the circuits and the courts generally come up.
Professor?
I think I have a somewhat different take on this. I think that there's a lot more consistency in the current pattern of decisions, what I referred to in my remarks as the emerging unified field theory of transformative fair use, than I would actually have expected for an approach to legal analysis that really is only 20 years old. And in particular now, we are seeing a convergence of the approaches of the two circuits that have done the most decision-making in this area, that is the 2nd and the 9th, which for a while we believed might be on different tracks, but which the last couple of significant opinions suggest are probably not. Now, one can agree or disagree with that emerging unified field theory, but I think it's remarkably consistent, even though, as Professor Besek states, sometimes it isn't clear how it applies to whatever the new thing is.
As a prosecutor, I'm used to the criminal statutes, and it's fairly consistent. I've done some civil work in the banking industry, and I see how it does vary from codified legislative law, whether it's at the state or at the federal level. So I yield back. Thank you.
I thank the gentleman. While we're waiting, I recognize the distinguished gentleman from Virginia, the chairman of the full committee.
Thank you, Mr. Chairman. Ms. Novik, and I direct this to Mr. Lowery, too, on this issue of remixing. I see that a lot. I see it's very popular with people, and I understand it. And I certainly understand the attraction of taking somebody's work and altering it and doing new things that can be very creative. But is there a way to it troubles me that if they take that, remix it, and are able to exploit it and offer it and actually copyright their new work themselves, that the original artist whose work has been altered doesn't benefit from that. I wonder if you have any thoughts on that, and whether if the standard is that you're allowed to do this, if you have to get a license if you're deriving a certain amount of commercial benefit from it, as opposed to just doing it for fun and to share with your friends, kind of thing.
Well, obviously, I've spoken a great deal about non-commercial transformative work, where, it's really, I talk to a lot of 16-year-old kids who are writing their own Harry Potter story, for instance, where they get to go to Hogwarts. And that's not hugely transformative. They frequently participate in all the same events of the book, But at the same time, it's non-commercial, and so I think the 4 points of fair use balance each other out. When it comes to commercial use, again, I feel that there are cases like.
You do agree that if they did that and hit on something really cool, that they would have to get a license from J.K. Rowling to.
I mean, I think that obviously, depending on what they were doing, a court would have to look at it, I'm sure, if it were not, and decide whether it were fair use. And part of the decision would be how transformative it was. And I think that most remix artists appreciate that and understand that and don't actually want to exploit work commercially and I'm speaking as a remix artist, somebody who is really trying to create new forms.
Sure. Well, let me ask Mr. Lowery what he thinks about my question about whether if you cross a certain threshold in terms of commercial gain that the rules should be different.
Often I find that although these are non-commercial works by those who remix it, they're distributed on commercial platforms. Like, for instance, I went to, I think it's fanfiction.com to look at that for a minute, and right away there's advertising on that site. The problem is not so much with the those who create the remix, is that the problem is that then there are these large intermediaries who then disseminate this work, who do make a profit, and they often encourage their users to make these remixes, which may be fair use or may not be fair use, but they may be fair use when they're non-commercial, but they become commercial. They become vacuumed up, sort of into the commercial world and then monetized. I have some examples on my laptop I can send to your office if you like. Thanks for the question, though.
If I just may add to that, though, that doesn't actually change what the artist is doing. But
they could still do it. It's just they don't put it onto that website. They could still do that. It doesn't infringe any rights of the remixer to continue to make that work. It's just.
It's a good point for additional thought, but I need to ask another question before my time runs out. So I'm going to ask all of you, so you're going to get another shot at answering a question of mine anyway. Professor Jaszi states that fair use is working. So I'm going to ask the rest of you if you believe that fair use is working for everyone or only for specific groups of users, and then we'll give you the last opportunity to rebut what your fellow panelists have to say. We'll start with Professor Besek.
I think that fair use is working for some users, but it's not working for all users, and it's certainly not working for all right holders. I think that one of the problems is these recent cases that deal with one party exploiting lots and lots of works at the same time is distorting fair use. The end that they want to serve, for example, an index of books or whatever, is truly a good one. I mean, you see these cases and you think, what a great public benefit. But the question is how you get there. What's the appropriate means to that end? And I think by trying to shoehorn it into fair use, we are doing a disservice to the Copyright Act, and it would be better if we could find another way to do that.
All right, let me jump ahead to Mr. Wimmer since I haven't asked him anything yet.
Thank you. I think it's generally working. We look at fair use both from the offensive side and the defensive side. I mean, newspapers and other news organizations have to employ fair use in terms of reporting on other people's work and curating other people's content. At the same time, we try to not have fair use become an impediment when we have commercial appropriation of mass amounts of our content. So our view is that it's generally working. This trend toward transformative use is concerning, but it's really been a fairly short-term trend in the overall path of the common law. So we think the courts will eventually get it right.
Ms. Novik?
I do believe that fair use is generally working. I do obviously think that sometimes individual artists, especially those working on non-commercial works, are at a substantial disadvantage when they are faced with a large media conglomerate or automated systems that essentially prevent them from exercising their fair use rights.
Mr. Lowery?
I generally believe for music it's working. I don't want to get too deep into it, but I think it's the photographers have probably been abused because you see plenty of, their business model has been really kind of wrecked by what I don't think was the intent of fair use. But I'm not an expert on that, so.
Well, on that point, if I might, Mr. Chairman, do you think that Congress should set distinctions based on the technology area between music, photography, books?
The fair use does manifest itself in different ways. I can't really say that I feel like a little out of my league on that legally, what they should. I'd be glad to think about that and give you a more coherent answer.
Yeah, we would welcome anything you want, any of you want to submit to any of these questions in writing. And Professor Jaszi, I promised you'd get a final word on your inflammatory statement.
And Professor, if you could accelerate it, because we're on a red light here.
I certainly agree that there are some groups of creators who are struggling in the current marketplace, but I don't think that struggle is really attributable to fair use, as it is instead to other conditions. I actually want to disagree mildly with Professor Besek about her example of a situation in which fair use isn't working, because I believe, in fact, that the recent mass digitization cases, Authors Guild against HathiTrust and Author Guild against Google in the Southern District of New York, are really excellent examples of the doctrine fulfilling its function. In those cases, material is being dramatically repurposed for non-superseding uses. The public interest, as the judges in both cases have acknowledged, in those uses going forward is enormous. No existing licensing structures are available to enable those uses. So far from thinking about mass digitization and all the benefits that it has brought to various communities, including the print disabled, for whom it's been my privilege to work on these issues, I must say that I would count that as a story of success rather than a story of failure.
Thank you. Mr. Chairman, I apologize for the extra time, but I thank you for it.
You're indeed welcome. The gentleman from Florida, Mr. Dutch.
Thank you. Thank you very much, Mr. Chairman. I'd like to thank the witnesses for coming and for being so indulgent to our schedule. Thanks for the testimony. I enjoyed reading it. I'm sorry that I haven't been able to be here for all of your presentations. I appreciate the ability to hear the lively and ongoing debate about what constitutes fair use. I was able to hear some of that, and I understood that it was a frequently litigated area of copyright law, but it's been especially interesting for me to hear the witnesses and in reading their testimony, just a very small sampling of the ongoing issues of the development of the law in this field. And what hearing all of this has reminded me is how critical the entire previous body of law is to our current understanding of fair use. It's easy to forget that by themselves, the words fair use in this context really have no meaning. Instead, fair use is defined only by the 100+ years of precedent in the United States. And as someone who's followed the ongoing negotiations for trade deals with interest and with some concern, I'm troubled at the suggestions that we just simply insert the words fair use into our IP section. Now, I support continuing to not only allow but encourage a country to develop fair use style exceptions, as our previous trade deals have. But what I don't fully understand is what the words fair use would mean when taken away from the precedents that define them. And because you can't build that precedent into a trade agreement or export it, it makes it exceedingly difficult to understand how this would work. And while our trade agreements allow flexibility for any countries that so desires to adopt fair use style exceptions, mandating it would just provide a loophole incapable of definition through which countries who, frankly, often care little about IP can excuse the lack of protection for authors. Fair use has no definition at all in the context of a trade agreement. So in doing just a bit of research for the hearing, I requested some background materials on fair use precedent. What I got was a multi-volume set of books, this being just one. And I've only read a few chapters of this one, to be perfectly honest with you. This is the first volume. It's a 700-page condensed It's a 700-page condensed version of our fair use law. Now, clearly, we're not seriously considering including a 700-page footnote in our trade agreements. Obviously, that doesn't work. Or in the reverse, we're not going to blindly assume that putting the words fair use or the 4 statutory factors into a trade agreement would result in the inclusion of the decades of precedent represented by the piles of books that are now sitting on my desk. Mr. Besek, I'm sorry, Professor Besek, you discuss cases in which our interpretations of fair use can threaten to move the U.S. out of compliance with our international treaty obligations. So even in the U.S., the fair use law, which is quite actually fluid and vague on its own, if you erase all the precedent behind fair use and started completely from scratch in this country, would you see the fair use defined by future courts in the same way that it is now? Well, let me go on. So going further, though, if you inserted Section 107 into another country's legal system without including any of our defining precedent, what's the likelihood that you'd come up with remotely similar meanings as other governments try to flesh out what this means?
It's certainly possible that there would be some aspects of it that would be similar, but they have such different, cultural and other factors. I don't think there's any reason to think that it would track our fair use law. For one thing, one of the aspects of fair use is that it attempts to accommodate First Amendment concerns, and those same concerns don't necessarily apply in other countries. But they've just come from a different tradition where they've had more explicit separate exceptions, which, and not this general kind of catch-all exception. And so I don't know that they would necessarily try to treat it the same way we did.
And safe to say their explicit exceptions may fill volumes of their own in those countries.
Probably that's true. I mean, they tend to have more exceptions and more very specific exceptions, but often they track the kinds of things that fair use would embrace.
But it wouldn't mean, in another country, it wouldn't mean the same thing. It could easily, the concern obviously is that it then becomes a loophole to completely overturn what is a really sensitive balance that we have in this country based on volumes and volumes of precedent. There's an important balance to be struck in our trade deals, and the words fair use themselves, I think, don't bring us anything. Mr. Wimmer, I wonder if you would agree with that.
I do agree with it. I'm not a trade expert, so I might be getting a little bit out of my depth here. But I've done legal work in about 20 different countries, and there are common law legal systems and there are civil law legal systems. We have a common law legal system, and that's the way fair use has grown up here. That's true for England, true for Canada, true for Australia. You go to all the civil law legal systems where judges don't have the same tradition of working to create precedent and expand precedent over time, and they really can't cope in the same way with these types of common law doctrines in a civil law society as we can. It's hard for me to see it working, truthfully.
Thanks, Mr. Wimmer. You may not be a trade expert, but your insight, I think, is right on point and most helpful, and I appreciate the chairman, and I yield back.
I thank the gentleman. I'm told the gentleman from Missouri has no questions. I want to thank all the witnesses and those in the audience because your presence here indicates more than a casual passing interest in this very important issue. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. The hearing is adjourned.